Garifuna Heritage Foundation for inviting me to speak today. Before I begin, I just want to say I'm conscious of the fact that I'm an outsider here, and that reparations is a very delicate issue. My background is in international law, so I'm going to be presenting on some legal aspects of one dimension to the reparations case, and that's the aspect concerning Indigenous reparations, as it's mentioned in the 10-part plan for reparations. So in March 2004, exactly 1 year ago, a meeting of CARICOM states approved the 10-point plan for reparations of the Reparations Commission to seek reparatory justice for the victims of slavery, genocide and racial apartheid in the Caribbean. With assistance from the London-based law firm Layday, the aim is to reach a negotiated settlement with the governments of Britain, France and the Netherlands, the responsible states and the jurisdictions in question. There can be no doubt that the depths of depravity wrought during the colonial period merit reparation. And while the legal aspects of the case are indeed problematic, this does not mean that the case lacks value in bringing attention to the legitimacy or moral dimensions of the claims at issue. Indeed, many lawsuits have been precursors to negotiated or legislative settlements. As the former Justice Guha Roy of Calcutta rightly remarked, that a wrong done to an individual must be redressed by the offender himself or by someone else against whom the sanction of the community may be directed is one of those timeless axioms of justice without which social life is unthinkable. That said, my presentation today does not deal with the reparations case in its entirety, which is indeed complex and delicate. Instead, what I will be discussing is the Indigenous dimension to the reparations question, particularly in relation to state responsibility and international human rights law. The current claim of the case includes an Indigenous component, with native genocide included in the title and Indigenous Peoples Development Programme included within the 10-point plan for reparations. It reads, genocide and land appropriation went hand in hand. A community of over 3 million in 1700 has been reduced to less than 30,000 in the year 2000. Survivors remain traumatised, landless, and are the most marginalised social group within the region. Land is thus mentioned in part of the reparations plan, as it is one of the most important issues facing Indigenous and Afro-Indigenous communities today, without which the development mentioned in the claim is hard to envisage. I wish to state in advance that the intention of this paper is not to pit one dimension of the case against the other, nor to hint in any way that one aspect of the case is more important or worthy than the other. What I aim to illustrate, though, is through legal analysis that there is a strong argument in relation to Indigenous communities and redress under contemporary international law. I won't delve into questions of non-retroactivity or statutes of limitations because it's not necessary for this particular part of the case. My focus will be on those CARICOM member states with Indigenous communities, and that is Belize, Guyana, Suriname on the mainland, and Dominica, St. Vincent and Trinidad in the islands. Although it must be noted that the situation varies considerably from one state to the next. What I will argue is that in the context of international law, there is a legal obligation on post-colonial states themselves to provide a remedy for former transgressions and to discontinue legacies of past wrongs relating to land and socio-cultural development of their Indigenous and Afro-Indigenous communities. So traditionally, reparations for Indigenous peoples may be afforded through one of two legal means. The first is usually an interstates claim based on state responsibility, and this is the classical international legal approach based on the premise that only states have rights and obligations. The second is a human rights claim brought by victims directly against the responsible state, and this is the result of the gradual evolution of international law from being based solely on the rights of states to also including the human person, so the rights of individuals and the obligations of the state towards their own citizens. Federico Lenzerini, one of the foremost experts on Indigenous reparations, argues that in addition to these two scenarios, there's a third scenario for Indigenous reparations which envisages a type of relationship similar to that arising between states. And it's based on the premise that Indigenous peoples never lost their sovereignty over their ancestral lands. Treaties concluded between native populations and colonizers are often considered probative of such sovereignty. So, for example, in the US between 1787 and 1871, it's estimated that over 650 treaties were signed between the federal government and Native American tribes, and many of these are still considered legally valid today. If we apply this third scenario to the Caribbean region, unfortunately we don't have the same wealth of treaty rights to rely upon, with the exception of some treaties such as the 1616 Treaty, which guaranteed the possession of Dominica and St. Vincent to the native populations on the condition that they abandon their claims to other islands. We have the Treaty of 1773 between the British and the then called Black Caribs of St. Vincent. The Treaty of Aix-la-Chapelle of 1748 left the islands of Dominica and St. Vincent to be reserved for the sole use of the native populations. However, the treaty itself was only signed by Britain and France, and therefore the native populations were not treated as sovereign parties to the agreement. This is clearly biased reasoning, of course, but it nevertheless means that there's not enough in terms of treaty rights to bolster a reparations claim against former colonial administrations for compensation for expropriated lands. This is the narrow confines of the law. And even in the event that there were the treaty rights, it still doesn't resolve the issue of land restitution itself, because land falls within the jurisdiction of the newly independent or successor state. Of course, the discussion of the erroneous application of terra nullius is also relevant here. The invalidity of titles of acquisition, so for example doctrines of discovery and conquest, used by Western states for claiming sovereignty over indigenous lands, has now been firmly recognised by international and national courts. The problem is that land claims are often met with the test that the people in question retain their traditional lands in order to retain them. So this has the paradoxical consequence that the more successful a state has been in dispossessing an indigenous population, the less likely it is they will be able to recover those same lands. Thus, the recognition of the invalidity of titles of conquest doesn't help the stringent and often essentializing mechanisms of law to prove continuity with native lands, and thus represents one of the many leftovers of colonialism, the legal order. So in relation to the current reparations claim, it's the first of these three legal scenarios, that is the state-on-state approach, that's being invoked. CARICOM states are making a claim on behalf of their citizens towards other states for historical wrongs, the legacies of which are very much still in evidence. However, there is a parallel scenario in the existing reality, and that's the situation of Indigenous and Afro-Indigenous communities, who represent a minority within the majority post-colonial context. Their situation diverges somewhat with regard to self-determination, cultural development, and particularly land rights. I'll come back to this point later. So what does international law say in relation to Indigenous reparations? And to what extent is the state responsible for remedying the past? With regard to the issue of state responsibility, CARICOM states with Indigenous communities do have obligations pertaining to cultural rights, non-discrimination and redress, which derive not from their devolved obligations from the United Kingdom, France or the Netherlands, but from current treaty obligations and political commitments entered into freely as independent states. For the present purposes, I'm only going to focus on those instruments that have been signed or adopted by CARICOM members of Indigenous communities, and thus the concrete obligations to which they are bound legally. Although Dominica is the only member state to have ratified, CARICOM member state to have ratified the ILO Convention on Tribal and Indigenous and Tribal Peoples, all CARICOM states voted in favour of adopting the UN Declaration on the Rights of Indigenous Peoples in New York on the 13th of September 2007. The Declaration specifically mentions the right of Indigenous people to practice and revitalise their cultural traditions and customs. This includes the right to maintain, protect and develop the past, present and future manifestations of their cultures. The Declaration also provides for the right to the lands, territories and resources which they have traditionally owned, occupied or otherwise used or acquired, and the right to redress by means that can include restitution, or, when this is not possible, for just, fair and equitable compensation for the lands, territories and resources which they have traditionally owned or otherwise occupied or used, and which have been confiscated, taken, occupied, used or damaged without their free, prior and informed consent. The same CARICOM member states are also party to a number of relevant human rights treaties, which, unlike the United Nations Declaration, are binding in character and which include provisions relating to the rights of Indigenous peoples and minorities, including cultural rights, land rights and restitution. These include the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, both of which expand on the normative content of the United Nations Declaration on Human Rights. Article 27 of the International Covenant on Civil and Political Rights, in particular, deals with the rights of minorities, including Indigenous peoples, and this has been interpreted to include access to ancestral lands and resources. General Comment number 23 by the Human Rights Committee, which clarified the content of this provision, makes it clear that the obligations pertaining to cultural rights in Article 27 are not only negative, but positive in nature as well. This means that the state has to take an active role in the facilitation of the cultural development of its minorities, including Indigenous peoples. But perhaps the most relevant instrument for shedding light on the Indigenous rights situation in the Caribbean context is the UN Convention on the Elimination of All Forms of Racial Discrimination of 1965, and this is one of the foundational international human rights instruments with over 177 states parties. So this convention recognises the right of Indigenous people to collective reparation in the event that they are deprived of their right to own, develop, control and use their communal lands, territories and resources, where they have been deprived of their lands and territories traditionally owned or otherwise inhabited or used without their free and informed consent. And it requires states to take steps to return those lands and territories, and this is included in the General Recommendation on Indigenous Peoples of 1977, also expanding on the content of the Convention. So the concluding observations of this committee, of the UN Committee on the Elimination of Racial Discrimination, which oversees the implementation of the Convention of the same name, raised various issues with regard to current inequalities in the post-colonial context in certain CARICOM states. The committee's concluding observations on Trinidad and Tobago between 1980 and 2006, for example, made continuous reference to the need for positive measures to protect and encourage the economic and social progress of the quote-unquote Carib people, as well as to the preservation of cultural identity and, importantly, compensation for the historical injustice they suffered. This is noteworthy since the committee places the responsibility for compensation on the state of Trinidad and Tobago, even if the original transgressor, the United Kingdom, who appropriated land at Arima, was not the modern state. The most recent UN Committee on the Elimination of Racial Discrimination report on the situation in St. Vincent is also telling, although not in relation to land. The committee noted that in 2004, the persons of quote-unquote Carib ancestry tend to be viewed at the base of the social pyramid and experience discrimination. Consequently, the committee recommended that the state party include in its next periodic report information on affirmative action measures in order to ensure the adequate development and protection of minority groups, in particular, quote-unquote, the Caribs. The UN Special Rapporteur on Cultural Rights, who produced a report of St. Vincent in 2012, also mentioned the lack of access to important historical documents as precluding cultural development, and recommended the consideration of the importance of Baliso Island for the Garifuna people, and to ensure that their relationship to the island as a site of remembrance is respected and maintained. Although this does not relate to land rights per se, it does imply that access to Baliso as a lieu de mémoire be maintained and facilitated by the Vincentian government for the Garifuna at home and abroad, which is significant. In relation to Dominica, the current situation of collective tenure in the Kalinago territory presents a situation that requires special measures by the government in relation to access for development. As there are no property titles in the territory, the land cannot be used for collateral for small loans, and thus socio-economic development is relatively stifled. The situation in Suriname, Guyana and Belize is even more problematic, as resource extraction and mining activities are prevalent in areas traditionally occupied by Indigenous and Afro-Indigenous communities. In 2004, the Committee on the Elimination of Racial Discrimination found that routine violations of Indigenous lands rights were taking place in Suriname, and that despite two judgments handed down by the Inter-American Court of Human Rights in relation to the Moiwana and Saramaka communities, Suriname had failed to implement the necessary legislation. As it stands, current laws permit the granting of concessions in Indigenous occupied territories. In Guyana, a 2009 High Court judgment placed an onerous burden of proof on Indigenous title to land, and prior to that, the Committee on the Elimination of Racial Discrimination issued a critical report of the Amerindian Act of 2006. In Belize, where international law has been successfully invoked before the national courts, legal reforms have not resulted in effective protection of Indigenous land rights. Threats remain from large resource extraction industries, compounded by a general lack of political will to defend Indigenous land security. So what becomes apparent through a greater analysis of the legal situation internally is that certain states seeking reparation are not providing for land security for Indigenous and Afro-Indigenous communities and perpetuating colonial policies against them in their own jurisdictions. Although this might not necessarily be the case for St. Vincent, it must be said. To conclude, land rights constitute the basis not only for economic but also socio-cultural development, and without access to land, many communities find themselves in a situation of great economic, social and cultural insecurity. If we return to the Indigenous development issue in the 10-point plan for reparations, we must interpret this in light of the current situation on the ground. In Trinidad, for example, the government is already in a position to provide the requested land to the Santa Rosa First Peoples community, which is publicly owned and requires a modicum of political will to achieve. In Dominica, the issue is one of land security and inequality, while in the mainland states we are dealing with human rights violations on a greater scale. In St. Vincent, the situation concerning land rights does require further research and is much less clear. If indeed the reparations claim succeeds, to what extent will the Indigenous Development Programme be implemented by the governments who are already unwilling to pursue development mentioned in the plan? To what extent are the National Reparations Committees considering this dimension of the claim in the current submissions? I argue that the answer to these questions is central to the credibility of the case as a whole. To quote Belle Antoine, who's a professor of law at the University of West Indies, with reference to Caribbean Commonwealth legal systems, if law has largely failed to acknowledge the customs and norms of important groups in society, it is fair to say that it has completely ignored the original peoples. Modern states have a current, albeit differentiated, responsibility towards their own communities, and it falls upon them first and foremost to address the question of land restitution, or land security, and redress. Until this is negotiated, there will remain a double standard in the claim for reparations, which will not ultimately strengthen the case overall. In sum, challenges to the enjoyment of Indigenous rights in the region are of course political and historical in nature, but no meaningful development of the communities discussed can be achieved unless certain CARICOM states assume some form of responsibility in relation to the restitution of land and the provision of land security. Sarah May, and thank you for listening, and I'll be happy to answer any questions or discuss aspects of my paper in more detail afterwards. Thank you.